You saw it happen, the other car drifting into your lane, a head tilting down looking at something in their lap. And then the crash happens. And now you have to prove what you already know you saw. I am Asthana from Caldwell Wenzel Asthana, and we handle distracted driving cases across Alabama, Florida, and Mississippi. Today, I want to talk about what actually proves that a driver was on their phone, and why the strongest evidence is not what most people think. For years, the standard move was to send a subpoena to the phone carrier for the cell phone records. That step still matters, but by itself, it rarely proves much. A phone bill can show that a call was connected or that a text was sent, but it cannot show what was on the screen. It cannot show whose hand was on the phone, and a defense attorney will definitely use that gap. They will say that the call was hands-free. They'll say that a passenger sent the text message. A carrier bill cannot answer either of those questions. So here's where the real evidence lives, inside the device itself. With the right court order or an agreement with the other side, a licensed digital forensics examiner can recover what the phone was actually doing, which app was open and for how long, whether the screen was on, locked or unlocked at the moment of impact, whether the phone was connected hands-free through Bluetooth or CarPlay, whether the phone was physically picked up based on its own orientation records. That's the difference between a guess and something close to an eyewitness account, written by the device itself. We recently resolved a rear-end truck accident case for $5 million. The cell phone download is what changed everything. Moments before the crash, the at-fault driver was on his phone and he was shopping for a Jeep. He had been shopping for that Jeep for the last 35 minutes. He never looked up. He never applied his brakes. And on that day, he killed 2 parents and orphaned a child. That cell phone download is what proved this. Here's what surprises most people. Carrier records last for years, but they were never very detailed. The records that actually prove distraction are the opposite. They're detailed and they disappear fast. That data typically survives on a device for only a matter of weeks. A software update, a factory reset, or trading the phone in can erase the data permanently. So a distracted driving case while using a cell phone is often won or lost in the first few weeks, not the 2 years that most people think of as their deadline. The quickest step that you can take when you suspect distracted driving by a cell phone is calling an attorney. And the fastest step that your attorney can take is sending a preservation letter. It is a legal demand that the driver preserve their cell phone. They stop any reset, trade-in, or update. If, despite receiving that preservation letter, the driver destroys the phone or takes any of these steps, the courts can penalize them for it. A judge can tell a jury to presume that that missing data would have proven fault. So where this crash happened changes how much the evidence matters. Alabama follows pure contributory negligence. If you are found to be even 1% at fault in the accident, you may recover nothing. But proof that the other driver was on their cell phone at the time of the accident makes it a lot harder for the insurance company to point blame at you. In Alabama, the law prohibits physically holding the phone, reading or writing texts, watching or recording a video, and reaching for a device in a way that takes you out of your seat. But it still allows for hands-free calls, voice-activated navigation, or a single swipe or tap on a dashboard-mounted phone. Florida uses modified comparative fault. So if you are found to be more than 50% at fault in causing an accident, you recover nothing. Otherwise, your damages are simply reduced by your share of the fault. In Florida, outside of active school and work zones, Florida law only prohibits manual typing, sending or reading text-based messages. It does not actually ban holding a phone to make a standard call. Because of this distinction, traffic stops outside of safety zones often come down to what a driver was doing on their screen, rather than the mere fact that they had a phone in their hands. Mississippi, on the other hand, uses pure comparative fault. So if you're even, let's say, 90% at fault, you can still make a recovery. It'll just be reduced significantly. In Mississippi, the law only reaches writing, sending, or reading a text message or social media post on a handheld phone. Hands-free and voice-operated use is expressly carved out. So an ordinary handheld phone call is not against the law in Mississippi the way that it is in Alabama. Alabama and Florida give you 2 years to file a personal injury claim. Mississippi gives you 3, but the evidence on the device does not wait for any of these deadlines. Now, something that's important to note is that in addition to the at-fault driver's phone, your own phone can also be used against you. Insurance companies can look at both drivers' phones, not just the one that they are defending. In one case, a witness said that they found the injured driver's phone on, showing a recent text and that she had admitted to the witness that she was texting while driving. The jury found her to be 25% at fault in causing the accident. If this case had happened in Alabama, the 25% at fault would wipe out her recovery completely. However, if it happened in Florida or Mississippi, she can still recover, just reduced by her at-fault percentage. So, be honest with your attorney about your phone use during the accident early. If you believe that the other driver was on their phone, here's what you should do right now. Call an attorney immediately before the at-fault driver has a chance to update or reset their phone. Turn off auto-delete on your own text messages right now. Write down what you saw about the other driver while it's fresh on your mind. Stay off social media about the crash. And do not give a recorded statement to the insurance company before speaking to an attorney. You know what you saw. The hard part is proving it in a way that the law will accept. That proof may already exist. It just will not exist for very long. If you believe that the other driver was on their phone, let us take a look at it. Our consultation is free and you pay us nothing unless we recover for you. We have offices in Foley, Mobile, Pensacola, Birmingham, and Jackson, Mississippi. If you can't come to us, we will come to you, and we offer virtual consultations. So call Caldwell Wenzel Asthana to see exactly what your case is worth, and we look forward to working for you.